Welcome, everyone. This is the 18th of my Arbitration Bootcamp series, and you'll see that my guest today, David Campbell, has just joined us on the screen, and I'll introduce him in a moment. He is the Arbitral Secretary at Arbitration Place. Just a reminder that if you miss any of the arbitration bootcamp series, you can find them on YouTube and catch up. I'm going to send you at the end of this seminar a list of all my previous sessions in case there's some topic in particular that interests you. For those of you who don't know me, I'm a partner at Learners, an arbitrator, and also a roster arbitrator at Arbitration Place. I'm also the editor and a writer of Arbitration Matters, which is a website that contains summaries of arbitration cases as they're released across Canada, as well as some commentary. And if you're interested in receiving for free the newest cases as they are released, you can subscribe and receive those every second Tuesday. With respect to the plan for today, I've got the Q&A box open. So if you have any questions for David, please do put them in the Q&A box, and I will do my best to ask those questions of David as we go along. But if I miss something, I'll do it at the end of the seminar. I promise, as always, to have you out in an hour. So now I'd like to introduce you to David Campbell, the Tribunal Secretary of Arbitration Place, and he focuses on international, including investor state arbitration and high-value domestic commercial arbitration. You can view his bio in more detail on the Arbitration Place website, but it really does show the range of disputes in which he's been involved and his expertise both as counsel and as arbitral secretary. He has experience, for example, in reinsurance, infrastructure, construction, ground lease, price set disputes, etc. He's had several appointments in which he has acted with and as Tribunal Secretary for Beverly McLaughlin and Ian Binney, but he is also available to take on any other mandates, and he's done so. He's experienced and credentialed. He's a fellow of the Chartered Institute of Arbitrators and has experience with most of the well-recognized institutional rules, as well as experience as Tribunal Secretary in ad hoc arbitration. And he's called to the bars of Ontario and New York. So I've invited David to talk about his role, how he got here, and most importantly, how someone in this role can add value to an arbitration. Most counsel and arbitrators who do almost entirely domestic work don't have a real sense of what a tribunal secretary does. So I'm going to ask that first question of David. What is an arbitral secretary?
It's a good question. It in some ways, when I describe my role to people, I sometimes say private judicial clerk. That doesn't really capture it. I was a judicial clerk at one point, but there's all sorts of back office and administrative stuff because unlike a courthouse, there's nobody else aside from the arbitrators, and you know you're dealing with the various institutions, and if you have to go overseas, that's another layer of complexity. So there's part of it is sort of small solo law practice management, but also combined with things you'd expect from a judicial clerk in terms of drafting, but then you probably wouldn't need as many, say, templates or precedents if you were a judge. And even then, like the complexity of these things requires a lot of information and document management.
I know that there is some disagreement among arbitrators about the extent to which the role of tribunal secretary can approach the role of arbitrators. So I've got a list of responsibilities here, and I'd like your view on whether they're appropriate for the role of tribunal secretary, whether it depends on the arbitrator, whether it depends on the the skill set of the tribunal secretary, because one of the real issues that parties may be concerned about is the delegation of the role of the arbitrator, who must be the decision maker in the arbitration. So the question really is, how closely can the tribunal secretary assume some of those roles and responsibilities? And I think that the clear answer is the tribunal secretary cannot be involved in decision making. So there's a clear line.
Right.
But there are other potential roles that are there to assist the arbitrator, which are somewhat controversial. So here's an example. You talked about administration and clerical tasks. Does that include something like proofreading the award?
Oh yeah, I mean, if you've got an award that's, some of these things are 3, 4, 500. The longest award I've ever done was 600 pages, over 600 pages. And if you've got 3 people writing it full time, the whole proofing to make sure that it's consistent throughout, because, English to English translation is, not the same if you're dealing with, say, a retired English judge or an American, but having that consistency and below the line edits, above the line edits, there's so much that is required, because nobody can write 100 pages without needing some sort of proofreading. And
What do you mean by
it's
above the line and below the line edits?
oh, so days for I was a law review nerd, so footnotes would be below the line edits, and just making sure, because footnotes are really important, especially in um, international arbitration, and I think also to an extent in domestic arbitration, because you want to tell the parties where in the record this stuff is coming from. It's not just my memory of it. It's, you can find, there's the transcript, there's the document, there's the witness statement. So when you're quoting whoever it is, they can see, oh, okay, well, I can go to that witness statement and I can see that this comes from paragraph 19 of that witness statement, or this is, you know, C 137, as there's that aspect to it, making sure that, because you're writing for the parties, you're writing for the party who's not doing well, and they have to sit down and be able to pick it apart. Yet afterwards, in investor state arbitration, for a fact that there's going to be a floor of Ivy Leaguers picking apart the award afterwards. Like, that is a fact.
So you're finding in the evidence, in the record, the place that you can insert the footnote to help the party understand where the evidence comes from.
Right, because I mean, the evidence should speak for itself. The evidence always tells its own story, right? Like, you can have the submissions of counsel, but like, you take all of their witness statements and expert opinions and exhibits and the hearing testimony and the submissions, and you make sure that you've got all that for each issue. And if you've got, like in a construction case, 50, 75, 100 issues, like there's a lot of lining that stuff up so that the arbitrator can sit down and just work through the problem. And, I've had cases with, 30 gigabytes of, of documents. So there's a lot of,
Yeah.
a lot of sorting. And if you've got, say, infrastructure projects, there's a lot of people and whatnot running around, and you have to make sure that they're all in the right places. So,
And
that
what you're
type of it.
describing,
Yeah.
describing is one of the benefits of having a tribunal secretary, which I do want to get to in a moment,
Yeah.
which is that if you weren't doing this, the arbitrators would be doing this at a higher hourly rate. So
Right.
one of the purposes of a tribunal secretary is that it's accepted that it will lower the costs of
Yeah.
the parties to have somebody else doing some of this administrative, detailed stuff.
Yeah.
But what about actually drafting the award? So you've talked about kind of the editing stuff you may do, but what about drafting, for example, procedural history? Is that something that a tribunal secretary would be asked to do? And if so, do you feel comfortable with that role?
Yeah, well, the procedural history is, I think it's right there in the young ICA best practices that procedural histories um, are definitely part of it. And what you really get in the international practice is procedural histories that can be highly technical. And I think the longest ones I've seen are like 60 pages because you need to list everybody who attended the hearing, which if you've got counsel teams of 20 on each side and you've got, a merits hearing followed by a quantum hearing, followed by all the witnesses who attended, it becomes and also depends on the procedural complexity. The most sort of procedurally fraught case I was involved in, we got up to procedure order 11, and I think Ian holds the office record with procedure order 19. And all that has to be spelled out in detail because, like, it for us in Canada, it's sort of hard to comprehend, but there are countries on Earth whose courts are not as reliable as we are. And if you don't spell out, and they have different legal traditions, and if you don't spell out the procedural history in that type of detail, the award could be set aside.
Yeah, I always think of the procedural history as being important to demonstrate to a reviewing court that both parties have been treated equally and fairly.
Yeah,
And so,
exactly.
what you're doing actually is a very critical part of the award, even if it's not part of the decision-making process.
Yeah, and I'm only
Yeah,
doing I'm only doing the draft too. I mean, but at that point, we've all sort of lived it and breathed it, and we remember everything that happened. But there can be a lot of attendance taking. Also, even on a domestic thing, if you've got a procedurally complex domestic case and it lands in some judge's lap, the judge is going to want to know how it got there.
yeah, and in that respect, it's very different from domestic court judgments because we don't see that kind of detail in the procedural history. So that's something that makes arbitral awards quite unique. What about, we're now moving into kind of a substantive realm. Do you have a role in summarizing the parties' substantive arguments in a draft award?
I can help with the drafting of that. So, for example, like you've got some institutions, and it's a very European way of writing. We see it less in Canada, thankfully, but some institutions really want the claimant said this, the respondent said this, the tribunal finds that. And a lot of it is, you need to gather all the things that the important points that the claimant said, and that's from the witness statements, the expert repent. You're going to the closing submission so that they've synthesized this for you, but you need to sort of gather that in one place so that you can say the claimant said, the claimant's position is that the evidence of Kim Lee shows, the evidence of Dr. Whoever shows, therefore the claimant is entitled to, the respondent says that and oh, it is a slow and cumbersome way to write. Um, but if you're doing work for the ICC, ICSID, uh, PCA, that's what they want.
Yeah, you make a good point that each of the institutions may have quite different requirements with respect to what an award must look like. So do you view yourself as responsible for making sure that the award meets the requirements of the institution. In other words, the tribunal may not have had an ICC experience, but it relies on you to make sure that that the award meets those requirements. Is that fair?
Yeah, I think that's fair because, if you're ad hoc or LCIA or something, there's not the oversight and scrutiny. So for instance, like I found PCA and ICSID. There's sort of a tribunal secretary, there's counsel, and they'll work with you and help you in the edits because you can have just reams and reams of engineering. Um,
So wait a minute, the institutional person will help you with the edits?
they can. I mean,
Okay,
we're talking like typos and things like
yeah.
that. Making sure that if you're filling in spreadsheets that you haven't valued something at $1.95 when it should be 195,000. I mean, so you work ICSID, you get a tribunal secretary. They tend not to be as involved as I am, but you also have like a sort of a little paralegal staff as well who helped you with filing. PCA has something similar, but
What's the
you're
PCA?
Permanent Court of Arbitration in The Hague.
Okay.
And I'm thinking specifically for PCA administered cases. And, the PCA you have to, they're really helpful in this regard, but they'll send you around their whole manual as to what a PCA award needs to look like. And that's not necessarily what a domestic award needs to look like.
So let's move further along the spectrum then about how involved you are in getting close to the decision-making process. Do you attend deliberations? And if so, do you participate at all?
Well, someone needs to keep the minutes, right? Um, that's sort of that's probably my primary role. I mean, deliberations sort of at that point, you've all gotten to know each other pretty well. And I think the only thing, you know, my job is pretty much to sit there and shut up and take notes.
And what's the
Mhm.
purpose of the minutes? You've got the three tribunal members, presumably talking about, and that's what we call deliberations, talking
Right.
about what the award will look like. And what's the purpose of your minutes?
Yeah, well, I mean, the purpose of the minutes is the same as sort of any corporate minutes. You want to, if you've got two or three of these things going on, you can't remember, oh my God, like we did that last week. What did we discuss? Oh yeah, who's doing this? Who's doing that? It, that sort of thing. Like there can be delegation of duties. What are the next steps? So, that's really like what you're going to want to have to remember 2, 3, 4 weeks from that point if you're going back and trying to remember, oh gosh. And you obviously, like any, say, corporate minutes, you circulate it to everybody afterwards so that they all know what the game plan is and what's going on.
So if your job is, as you say, to take minutes and shut up, does that mean that you have no role in saying, well, wait a minute, the witness X said such and such, for example?
um
Because
I might.
arguably that's not part of the decision making.
Yeah, I mean, I might chime in that, did you remember such and like? Yeah, we did. Okay. But the thing is that it's at its best, deliberations are all very collegial and collaborative. So if you've been sitting with the tribunal all day, every day, breakfast, lunch, and dinner in a hotel, for 2, 3 weeks, I mean, like it's just sometimes these things are very organic. So you're there, or sometimes I don't know. I mean, hearings are funny things, right? But they're just organic and they're human, and sometimes it's clear to absolutely everybody what's the outcome's going to be on something.
Um, what about legal research? Is there ever a role for you to play in doing legal research?
So, not legal research in the sense of going on to Westlaw and looking up cases. I can't say that as an arbitral secretary, I have lacked any legal reading. If you see the size of the books of authorities that come in um, by the, bankers boxes full of legal authorities, you know, some of
So,
that.
so does that mean you're summarizing cases for the tribunal? You're not looking for new authorities,
I'm
right?
I'm never looking for new authorities.
Right.
The role of that's the role of counsel to find new authorities. But for example, like so I because I've got American legal training, like if you've got a whole bunch of US case law, like I can plow through that and see the nuances there way faster than somebody who hasn't been trained in the United States. I was thinking of one thorny state law issue that came up. But you're also making sure like some counsel cite a case for such and such proposition, and you just you want to check under the hood, make sure that that's what the case says, because sometimes it's not what the case says. For any number of reasons,
Yeah.
they were working too quickly and they just cited a case and it doesn't really say that, or but you have to you know check these things, right?
So I've got a few questions in the Q&A box and I will get to them in a moment, but
Sure.
it seems to me that it's absolutely essential if you're going to suggest, for example, the parties, if the arbitrator is going to suggest to the parties, my understanding is this request for a tribunal secretary rarely comes from counsel. But if a tribunal wants to propose to the parties that a tribunal secretary would be useful because of the complexity of the case or perhaps another reason, and that this will reduce costs, which is often the reason that is proposed by the tribunal. How do they satisfy the parties and counsel that this really is going to be cost effective? And secondly, that the parameters of the work being done by the tribunal secretary are clear. You've
Uh,
talked about what you do
yeah.
and you don't do, and how do you avoid a concern that you're going to step over a line and be a member of the tribunal making deliberations,
Well, I can
doing
tell you that
deliberations.
from my retainer letter, I've got the retainer letter that looks for all the world like the young ICA, because it's cut and paste from young ICA what you will do, what an arbitral secretary can do, and that's what I do. There's no I don't know what other arbitral secretaries do. I don't know what other uh, arbitrators do, but I know what my tasks are, and I stick to my lane because that's how I keep the lights on and keep doing this. I'm just gonna f follow the recipe and tell them tell them what I'm going to do, and then I do it. Uh,
Okay.
but in terms of
Yeah.
cost savings, in some ways, if you've got like the hearing I just finished, there were six lawyers at one table and five lawyers at another table, and lots of money in dispute. My fees are less than a rounding error in the context of something like that. Um, if it's an infrastructure dispute with 55 issues or something, like I don't charge that much. I'd say I'd have competitive rates for Toronto. So, because, it's like me and a laptop in an office and some bookkeeping. I mean, there's not much more than what you see here, right? Like,
Okay, you've referred a couple of times to the Young ICA guideline, and
Yeah.
I'm gonna speak about that later if we have time. But just for people who are viewing this interview, there is a resource which I will circulate with the video at the end after this webinar is completed, I have a link to these guidelines. And essentially, Young ICA has created guidelines about the appropriate role of a tribunal secretary, and this was created because of disagreements or ambiguity about what that role was, and specifically the concern of parties that the tribunal secretary may just turn into a fourth tribunal member, which is not what anybody wants, and which is accepted broadly as not an appropriate role for the tribunal secretary. But let me get to the questions. The first one is, what does without prejudice mean in an award that terminates an international proceeding for non-payment of deposits without prejudice? Do you know the answer to that question? I'm not sure. It's an arbitral tribunal secretary role question. Should I read it again?
That sounds like they're asking for legal advice. So I'm I'm going to decline.
Yeah.
If we can go to the next question.
Yeah, whoever
That
asked
sounds
that
like
question, if
putting
you
on my
want to,
counsel hat and
yeah, if you want to reframe
yeah.
that so it's a tribunal secretary question, I'd be glad to read it out. Um, the second one looks to be almost the same question. And so if you wouldn't mind rephrasing that. We've then got another question, which I think is on the minds of many attendees here. The issue that everyone wants to know is, how do you get an assignment as a tribunal secretary, especially if you do not know many or any international arbitrators? Do you canvass people, write them a letter? What qualifications do you need to emphasize? Do you need to be certified for some organizations?
Yeah, my entry into being an arbitral secretary was sort of half unexpected. Um, what happened is I did the first class of the TCAS course back in 2016, 2017, which is the first time I met you. And then after that, I did the Columbia Chartered Institute's course down in New York City, and that was fun. I was just doing this because it seemed interesting. It seemed like fun. About a year later, a reinsurance tribunal was being put together, and Kim Stewart asked Bill Horton, "Do you know any young lawyers who know about um, arbitration and insurance?" And I'd done a lot of insurance up to that point, and he said, "Well, that that sounds like David." Um, so they called me up and I said yes. And about a year, and that was fun, great experience. And about a year later, Kim called me up and said, "Would you like to be a tribunal secretary for Beverly McLaughlin?" And I said yes. And Snowflake turned into Blizzard. I can tell you that like ICSID in Washington has sort of a group of tribunal secretaries. The LCIA has a roster, but unless you're sort of in that whole London scene, it would be pretty hard to break in. I couldn't do this a second time. I really don't know how this all panned out for me.
Yeah, for you, it sounds like it was kind of being in the right place at the right time. But let's
Yes.
go back to what you just
Yeah.
said about the institutions. So first of all, if you are interested, is it worthwhile contacting the institutions and finding out if they have a role and how you get considered for that role?
Yeah, I mean, I can tell you that like the PCA has a council team, but if you want to work for the Permanent Court of Arbitration in The Hague, you have to live in The Hague. Similarly with ICSID, just about I'm pretty sure everyone I know so ICSID is the International Center for State Investor Disputes. It's part of the World Bank. It's based in Washington. Again, you probably should live in Washington. If you want to work for the World Bank in Washington. I don't know quite how all that works. I'm sort of giving tips and strategies on how to win the lottery over here.
Yeah, I mean, what I've heard, and I've heard this from Bill Horton, is that he has had need for an tribunal secretary, and he's spoken to colleagues
yeah,
about this, and that none of them really know how to find one. So, and the reason for that is people who have the skill set don't necessarily market themselves in this role. And I'm
yeah.
not suggesting that there is a ton of opportunities for this work, but there may be some for somebody who wants to market themselves in this way. But the challenges you and I talked about when we were kind of preparing for this session is that there's a kind of very narrow there's kind of narrow scope for the expertise. So you want someone who's not too experienced, because the concern is that that person will then want to participate as if they were an arbitrator. And yet you don't want anybody with no expertise, because then the assistance that they can give is very limited. So do you know anybody who's worked for an institution in some way and has become a tribunal secretary as a result?
I mean, you'd really have to talk to the ICC people, or some of my work is through institutions. Some of it isn't. I mean, I've got sort of a note here that, me as puppet master telling Ian Binney what to do. Like, there's a good image. Like, you try and tell Ian what to do.
Yeah.
Ian's going to do what Ian's going to do. I miss he just yeah moved out, and I miss him dearly, but he was here yesterday. Anyway, but
But I think part
anyway,
of what you're describing is not only the retainer letter or engagement letter that you're talking about, which sets out the scope of your role, but also the trust you have in the arbitrator or the tribunal that they will
right. Yeah.
supervise you properly, and they won't allow you to step into that role.
Yeah, and maybe there was particularly bad behavior on continental Europe. I don't know. Legal education, and even in some countries, professionalism can vary. We just take it as a granted that law school is the same everywhere, and it absolutely isn't. Legal training in the UK is different again. It's different on the continent. It's different throughout the rest of the world. So what a tribunal secretary means to a German arbitration is sort of something totally different than what we're talking about, which is sort of you wind up at cross purposes. Anyway, I do know that there are arbitrators who do a lot of, say, work in The Hague, who have sort of a regular pool of um, tribunal secretaries. I think most of them are either Swiss or French or something like that. I
But you're confirming my suspicion that this is largely international work. And there are very few domestic arbitrations in which arbitral secretaries are used. And I think the reality is that's because counsel are not familiar with the role and don't know how to ask for that. Is that fair?
Yeah, I think that's part of it. I I suspect that uh, here's an opportunity that I've got just sort of circled and highlighted is all the LRT construction in Canada is going to yield a whole lot of arbitrations, I suspect. And I've had one LRT file, not in Canada, but criminy. Like, I've done a lot of highway cases, but the amount of stuff that goes into light rail is huge, and you need an extra
And
pair
these
of
are
hands.
domestic cases?
That one, I mean, that one wasn't a
Okay.
domestic case, that was overseas, but the fact is, I mean, we've got light rail construction in Toronto, in Montreal, in Ottawa, and there's just so much engineering and design that goes into every aspect of that. So if you've got a big LRT dispute, I don't know, could be I suspect there's going to be some about delay. I'm just,
Are there
yeah.
some cases that are more suited uh, to using an arbitral secretary than others?
Yeah,
I mean,
I'd say,
complexity is a clear
yeah,
example, because keeping track of the evidence and the documents, that sort of thing is something that somebody in your role would do. But are there kinds of cases where not necessary?
well, I mean, I'd say the ones where it tends to be necessary aren't anything to do with public infrastructure. Huge construction projects. A lot of my work has been highway construction. Also, one thing people don't realize about Beverly is that this is her least popular book, The Canadian Law of Architecture and Engineering. She is a construction lawyer. No one seems to think of her as such, but it's
Let me take
true.
a question again here.
Yeah.
Does David have any advice for clearing conflicts if we're part of a mid-sized big firm? And I think this question actually leads into another area that I wanted to talk to you about, which is that your role requires the same independence and impartiality that an arbitrator has, which means you are required to run the same kinds of conflicts,
Right.
which means, to go back to this question, the larger a firm you're in, the more difficult it is to clear those conflicts. And in fact, and I guess I'm answering this question, but I'll once I finish, David, I'll ask you if you have anything to add. And it is invariably the case that arbitrators or people, if there's someone who's doing tribunal secretary work, have greater difficulty accepting mandates in large firms than in small firms because of the potential conflict issues. And by conflicts, what we mean is disclosure requirements. And that is something that arbitrators have foremost in their minds, and arbitral secretaries as well, because the obligations are the same. That if there's a potential issue which could give rise to a reasonable apprehension of bias or justifiable doubts about the independence or impartiality of the tribunal or the secretary, those are matters that must be disclosed. The parties must consent to waive those potential issues in order for the appointment to go ahead. And there are some kinds of conflicts that are just too close that cannot be waived. So essentially the answer to this question is they're the same kind of issues that arise when you're appointing an arbitrator as you are an arbitral secretary. Is that a fair summary, David?
Yeah, and I think all of us, even if you're carrying on a typical barrister solicitor practice, you have to do a conflicts search the second a file comes in. Like that's the first thing you do before you can accept a retainer to make sure. But it's sort of I don't have very many conflicts just because I'm sort of basic. I'm like, you pretty much see most of the operation right here. And then I suspect the other thing with mid to large firms, and the term mid to large firms varies depending on your postal code. Um, you might not be able to keep your rates down, which is the other, because I'm running a lean operation here, I can have reasonable rates because I'm not paying an assistant and a law clerk, a marketing team, et cetera, et cetera. There's not the same sort of overhead I'd have at a firm. So I,
Yeah,
yeah,
so this questioner is actually from a large firm, and I would recommend that you talk to your partners who are doing arbitration in your firm to get
yes,
specifics, because part of the answer to your question is it depends how your firm's conflict system works.
yeah,
So I've given you the kind of generalities of how it should work, but the specifics of how you clear conflicts is unique to your firm.
yeah, yeah,
So that's the best
absolutely.
answer I can
And
give.
you can wind up with conflicts that don't show up in a database because you've got some sort of personal connection to something, and you have to be mindful of that because the longer you spend at the bar, the more personal connections you have or should have. I mean, I guess there are a few outliers, but
Yeah.
yeah.
And for some guidance on this, if you're not familiar with it, the IBA guidelines on conflicts of interest in international arbitration is the guideline that everybody goes to. People don't necessarily agree with the recommendations, but it's at least a place to start on the subject of what kinds of relationships must be disclosed. I want to go, David, to something you said about having a retainer agreement. So you've got your own retainer agreement, but it raises questions about who's actually retaining you and who's actually paying your fees.
Yeah. So there's sort of a standard letter that the arbitrator will, I propose to appoint David Campbell. His CV is attached. These are the tasks I propose delegating to him. There you go. And typically the parties write back and say, yep, okay. And then in terms of my terms of appointment, it the easiest thing instead of drafting up separate terms is just say, the arbitrator's terms of appointment apply mutatis mutandis, and there you go. I mean, obviously the fees aren't the same, but you onboard everything else, and that's the simplest way to do it.
And so the parties are actually retaining you, not the tribunal.
Yeah, well, this is so the ICC does not pay anything. I mean, you have to have party approval for the ICC, but the ICC will not pay a cent for a tribunal secretary except for travel expenses and a per diem while traveling. So in that situation, it comes out of the president's pocket.
Or as the tribunal members may negotiate amongst themselves.
It's typically the tribunal. The president has it come because the president gets paid more than the other two. So
And usually is expected to have done more work on the award.
yes,
Yeah.
yeah,
Okay.
and so that was sort of the ICC's attempt to rein in, I gather, some bad behavior. And then, like, if you do say the LCIA, in order to, make sure that tribunal secretaries are at a whatever level, they cap the fees at 150 pounds an hour, which is 250 Canadian thereabouts. Um, because
So your fee is generally or maybe always less than that of the arbitrators.
it's always less than that of
Yeah.
the arbitrators.
Okay.
Always.
I
Yeah.
have another question. What about an older attorney with a lot of local practice experience who would like to get into this? Is this a young person's area? Can a retired person get into this? If so, how? Yeah.
The answer is no. There was some ages ago, the LCIA had some issue with a QC, then a QC, wanting to be a tribunal secretary, and they said no, no. It, it's too likely to be a shadow arbitrator if you're um, too senior.
Yeah. And it makes me think that this person should consider being an arbitrator
Yes, yes.
based on their experience.
Yeah. Go be an arbitrator, or to take the TCAS course. It's an excellent course. You'll meet people like Lisa, and terrific, all sorts of arbitration training out there. And just as an illustration, I have this. This was the annotated rules when I started. um, and this is the annotated rules
This is the
2019.
Arbitration Act, Annotated
Yeah.
Arbitration Act. Yeah.
Yeah. So I mean, it just sort of shows you how how much in just a few years arbitration is commercial arbitration is increasing.
Yeah. Another question, and I think this is an important one. Are all the assignments in all other venues like Europe so that extensive travel is required? Are there virtual arbitrations that a tribunal secretary can do online?
Mercifully, yes. Um, my so the first thing I ever did with Beverly, I barely met her for like 30 seconds. And this is before the pandemic. Then next thing I know, I'm being flown over to London for a first procedural meeting, which was like 3 hours. Don't go to London for the day. Just don't do that, okay? Um, Mercifully, with the pandemic, that sort of thing ended. Eh, for like those short trips, those short trips ended. But like I'm just back from a hearing in Singapore, and you can't do that virtually. She and I had one in Australia, and we did most of that. Well, it didn't actually go, but like you wind up doing it at odd hours during the pandemic. Like one of our first virtual hearings was like the 3rd of April 2020 because we were supposed to be down in Houston, and mercifully it was virtual, and that was super easy. A lot easier than going to Houston for 2 days. And so a lot of the really excessive travel that there was in 2019 has gone away. But, right before the pandemic, I spent 5 weeks in Fredericton, New Brunswick, January and February of 2020, getting ready with my own sort of personal lockdown in a long hearing. So, by the time lockdown came, I was accustomed to sheltering in place.
I think
Um,
anybody who has an international arbitration practice does a lot of travel.
Yeah,
That's what
and
I've observed.
Zoom calls at strange hours of the day. I've had to, get up at 3:30 in the morning for a 9 a.m. in London, which is better than having to go to London for half a day.
Yeah.
So,
We've got about 10 minutes left, and I have been monitoring the questions, so I think we can take a few minutes. I mean, really, what is the value proposition to parties and counsel um, to have a tribunal secretary?
yeah, certainly the value proposition is that it's so much of what I do is data and information management, and especially on big claims, whether they're international or whether it's, infrastructure. And there's a lot of infrastructure. Like there's Arctic construction is a huge one. I've seen a lot of Arctic construction work or road work or things like that. Those highly technical, very large disputes, somebody else, not Beverly, not Ian, should be organizing some of the stuff so that in a flash you can say, okay, we're talking about the, I don't know, geotechnical stuff comes up all the time. The geotechnical boring samples in this section of the roadway, and you need to know the timeline for the that the borings were done, and the subcontractors involved and the people in charge of the subcontractors, like all that sort of stuff where you're doing the sort of really heavy um, engineer engineering or trying to recreate whatever the engineers were doing on the ground. That requires, I think, requires a second pair of hands, because otherwise it there's just you got like 10 gigs of shop drawings that
Right.
you have to, and matching the shop drawings to the IFCs to the as builts
Yeah,
for the,
you're losing me there, David. You really
yeah.
are.
Yeah.
But what you're talking about is you can help focus on the most important, help the tribunal focus on the most important technical stuff. I think that's what you're,
Yeah, that's just it. Is that there's a lot of feathers flying around, and they need
yeah,
to focus on the important stuff and have the important stuff right there at hand, as opposed to trying to click on endless
yeah.
folders and subfolders. I manage this all in databases.
So we've talked about the benefits from a cost perspective, because if you weren't putting all these documents in bases and organizing procedural history, et cetera, the tribunal would be doing that. So we can see the cost savings. we can see that there would be help in you doing some of this administrative stuff that we've been talking about. Can you fairly say that because you're doing that full time during the arbitration, that generally the awards are being delivered earlier to the parties because the tribunal doesn't have to weigh in on, 3 members of the tribunal don't have to weigh in on this stuff and perhaps duplicate efforts?
Um, I mean, I'd like to think so. And certainly, some of the stuff can be moved along with coordinating tribunal members who, even in Canada, they might not all be in the same time zone. And making sure that everybody has the same documents so that, and the same drafts. Uh, there's a lot of back office coordination that's and project management that's involved to make sure these things get out. And people want to do a good job, and they want to make sure it's the best result possible. And corrections happen, but they can be super irritating when you think that you've really checked everything. I mean, it's just a bit rough on the old self-esteem. Obviously, legitimate corrections
What
need to be
about
made.
any downsides to having a tribunal secretary, if there are any?
It could increase costs. I
Wait a
mean,
minute, that's not what I've been saying.
yeah, I know. I
So
mean,
tell me.
but it depends on the type of case, right? It's all so fact specific. Like this one back here involving all of the liquid natural gas in the Crimea, that one took a lot of organizing. But
But
if
how
it's
does that increase costs if the tribunal
Oh,
would
no.
otherwise be doing it?
But by contrast, so one of them, but if you just have like a very small dispute where there aren't many um, issues at play, there's not a lot of stuff going on. If it might increase costs, but I know that there are instances I've heard of internationally where arbitral secretaries behave badly. But
Okay.
that's just that's just life, right? I mean, I've even heard of some lawyers in Toronto behaving badly.
Is there a concern, a legitimate concern about duplication of efforts?
I mean, there shouldn't be if it's a good relationship between the tribunal president and the arbitral secretary. Like we've all had, at some point you've been a junior for more senior counsel, and the idea isn't for the senior counsel to do it twice. It's the same junior senior type relationship that the junior's doing what the junior should do so that the senior counsel can go do what the senior counsel does. It should be that sort of relationship.
Okay. We've got just a couple minutes. I'm gonna let our viewers enter any other question they have in the chat box. But in the meantime, I'm gonna say, is there anything else that you haven't mentioned that you'd like to say about the role? I mean,
Just
I think
that,
what you've said is there's not a lot of opportunities to do the work. There may be some, and we've given some ideas about how to pursue it, but really this is all about how tribunal secretaries can make the lives of arbitrators easier and save costs for the parties.
yeah, and because at least where a lot of my work has focused has been on cases that have a lot of large engineering projects. That's where you're going to see the biggest bang for the buck in term and those are the those are the ones where you really need a second pair of hands because there's just so much going on. Um,
But a large commercial case could be similar
oh yeah,
too, right? A
absolutely.
ton of documents,
Yeah.
multiple witnesses, many hearing dates in various, hearings taking place in various places, physically. Like I can see that kind of a case could really benefit from an arbitral tribunal, lots of legal issues, that sort of thing. So you've been talking
Absolutely.
about the specialty areas that you've been involved in, but it seems to me that there are much broader opportunities than that. Am I right?
Yeah, I think absolutely. I mean, how many of those cases are floating about? I don't really know, but absolutely anything where you've got 10, 20, 30 witnesses and a related number of documents, that's where you definitely start seeing the need for a tribunal secretary, because it just makes more sense than somebody else getting tangled in the weeds, to when everybody wants to have the highest quality product at the end. They want an enforceable award that is correctly decided on the laws, the fact and the law. Like that's the goal. But absolutely, yeah, big commercial cases, rent reset would be another one. Those can be devilish, as you know, with all the issues flying about.
All right. Well,
Hmm.
thank you so much for giving us your views. I don't have any additional questions in the Q&A box. So I'll close now. After this session, as you know, you'll get a recording of this with reference links to the references we've talked about. And you can also see this in my other sessions on YouTube. The next arbitration matters is Arbitration Bootcamp is October the 17th at noon. The topic is defaulting parties, which is a really difficult one. Tips for both arbitrators and counsel when one party does not participate, how to proceed with the arbitration and get results without risking the award, without risking a set aside on the basis that one party has not had an opportunity to be heard, because that engages some of the fairness issues that are central to arbitration. So thank you very much for joining us, and I'll see you next time.